Dear friends, most of us do not know about John Marshall as the Chief Justice who worked for more than 34 years in United States of America. I say that he is John Marshall the Great, I say, because he worked as the Chief Justice during 1801 to 1835. When I was appointed as the professor of law in Lingayas Vidyapith University, Delhi, the chancellor of the university asked one question about John Marshall. Actually, he studied engineering and management, the chancellor of the university. But he has a lot of aptitude for legal studies. He's very much interested in a legal subject. He asked a question about this John Marshall. Thereby, you can imagine the greatness and the achievement of John Marshall. Before saying about the achievement of John Marshall as the Chief Justice, let's have some glances about his education. His complete studies was carried out by his father. Father taught him up to 14 years of his age, John Marshall's age. Very interesting and wonder also. Only after 14 years, he went to some college. There he attended from May to July, so only 3 months, May, June, July, 3 months he attended the lectures about law subjects. Actually, his favorite subjects are English literature and Latin. Thereby, you can imagine how his father has inducted a spirit of learning in him. And after attended the law lectures in some university, college of Williams and Mary, after obtaining the qualification, his law education, everything, he became a very, very talented advocate. He proved his mettle as an advocate. Because of that, he was also given an assignment as a member to write the Virginia Constitution at the very early age, beginning age. Later, he became the Secretary of State during John Adams as the president. And finally, hardly at the age of 45, when Jefferson was the president of America, he became the Chief Justice, hardly at the age of 45. Then he started creating wonders in legal arena. One institutional wise, that is the great achievement at the very beginning. That is, when he was during his tenure as the Chief Justice, all the judges in his court they had only one voice, and that voice is no question of divergent opinions, nothing doing, and that is for the first time in legal history we can say. And that voice is the sound of the Constitution. That is the point to be noted. And now we shall come to this and the actual achievements of John Marshall in brief. The first achievement is constitutional supremacy. What is the constitutional supremacy? That means constitution is important. It's the first and foremost law, the law of the land. And all laws must be in consonance with the constitution. And that has been established for the first time in legal history in Marbury versus Madison case. And you must have studied about it. It's a very popular case, a sensational case, a historical case. And for the sake of at least law students, I would like to say something about this case just for a minute or two so that you can have an idea about the constitutional supremacy established for the first time in the history of America. Here, Marbury versus Madison. In this case, Marbury was appointed as the judge by the previous government. Madison is the secretary of the government. This Madison did not permit him to join as the judge. The reason is this. Some judges, when the government was stepping down from the power, some judges were appointed in the midnight. Overnight, some judges on political interests, vested interests, they were appointed. And one of them is Marbury. So they are called midnight judges and appointed on political interests, vested interests. And immediately, just in 2 days, new government, Jefferson government has come to power. And Madison, the secretary, government secretary, made an objection to that. They are not, they are, see, the appointments of the judges were not made on genuine grounds, on wrong grounds, false grounds. They were appointed. So let us not appoint them. Let us not take them into position. So there he has been prevented. He was prevented from joining as a judge. Anyway, the case has come to John Marshall when he was the Chief Justice. Then he decided like this: Marbury has the legal right, he said. Because he was given that appointment, he has every legal right to join. The second thing is, when there is a legal right, there is a legal remedy. What is that? Issue of mandamus, so that he joins the duty as a judge. But that legal remedy is also not possible. Why? The reason is there is a clash between constitution and the legislation made by the parliament. The parliament legislation, that is Judiciary Act, section 13, says yes, the Chief Justice can issue what? The writ of mandamus. He has the power. Section 13 of Judiciary Act says that legislation. On the other hand, the American Constitution, Article 3, says no. Only officials like ministers, consuls, such cadres. Only in respect of such cadres, the Chief Justice can issue the writ of mandamus. That is the provision. So there is a clash, very apparent clash between the legislation, Judiciary Act, Section 13, and Article 3 of the American Constitution. Then he has chosen a constitution. So constitutional provision is important. We must give the importance to constitution only. That is the ultimate law of the land. We have to follow that constitution. So he has just here Marbury's application is rejected, and he was winning the case. He won the case finally, state secretary. So that was the case. So here, what is established is constitutional supremacy. It is ultimate law of the land. We have to follow the principles of constitution. That's all. That is the matter. For the first time, and here it is a historical judgment because for the first time in the legal history, it is it was John Marshall who obliterated the provision or some section established by or some legislation made by the parliament for the first time. Okay, that is constitutional supremacy in brief. And now coming to judicial supremacy. Judicial supremacy, how? By way of judicial review. So judicial review means, you know very well that judicial review means the judges has the power to review any legislation, any act, any rule, any order, and any legislation made by either parliament or legislation. It is the weapon of the judges. They can review it. If it is against constitution, they can just obliterate it, subside. They can set aside. That is judicial review. The power of the judges. The first time in legal history, it is John Marshall who has established it, and now the rule of law. So the rule of law, supremacy of the rule of law. You know very well that the rule of law is nothing but equality, principle of equality, and the spirit of legal spirit, importance to legal spirit, prominence to legal spirit. What is law? What is correct? What is exact? What is the natural justice? And everybody must be treated alike. So that is the rule of law. And particularly, most importantly, the government should not follow any arbitrary power, and the people should not be suppressed by the arbitrary power of the government or the public authorities. So that is the rule of law. So supremacy of the rule of law has been established by Chief Justice John Marshall for the first time, and now the next last one is judicial statesmanship. What is the judicial statesmanship? The greatness, the importance, and their dexterity, sagacity of the judges. How? It lies in the fact that judges are not expected to make laws. They are only to interpret laws, to give, to say what law is, and to say, uh, to decide what the Constitution says. What is the meaning of the provision of the Constitution? The interpretation of the Constitution. That is to be observed. And only that job must be carried out by the judges within their limit. And it is the actual, these are the principles that are being followed by almost all countries in the world now. And at the same time, particularly our country, our Indian judiciary has been following these legal principles very systematically. And there is a lot of influence by American judiciary, and that too during the period of John Marshall. So that is the greatness of John Marshall. Without having a formal education in school and college, just studied, educated by father and some one pastor, local pastor, and that man has educated. And apart from that, there is no question of formal education, but he rose to an occasion. There is a lot of original thinking, legal thinking, and it has been extended to almost all courts, all countries' judiciaries nowadays. This is about John Marshall in brief. Thank you very much. If you are impressed, please subscribe and encourage.